that it would take to set a fire in the bedroom where the child is in the crib sleeping. A burn pattern that goes from underneath that child towards the door of the bedroom that is caused by likely something. It's a significant burn pattern as he described it. It could have been alcohol, it could have been something else that gets consumed by the fire, but a significant burn pattern shows that there is something said significant and intentional. And at that point, to start a fire in that room is hidden, and to walk away, not trying to escape from that fire, and immediately starting another fire in the living room. And then to claim it's an accident, that it got out of control, that's an extreme recklessness, and that's intent, that's maliciousness, that's a definition of malice. And as you walk away from a fire that you've just lit in another room with a small baby, walk into the front room, light that fire, and then leave the residence standing outside watching it burn till it becomes too much to go back to. That's malice. And so malice is here on both counts, because all that murder requires is malice of forethought and your fascination with fire, to watch that burn, knowing that that child was in there that was going to die, and not calling 911, not saving that child when he could have, and not having started the fires in the first place. He has to take responsibility. And so there's much more here than probable cause. So I would ask the court to find probable cause in both charges in this case.
All right, thank you, Mr. Thompson. The testimony, listening to both sides, question testimony. I believe the state has, in fact, met their burden. So therefore, I am going to find that there is probable cause to charge the individual with the bound over for General Sessions Court for both
Law. Case number CF 2014-5869. Verdict, count 1, sexual battery. We, the jury, impaneled and sworn in the above entitled cause, do upon our oaths find as follows. Defendant is guilty of the crime of sexual battery and set punishment at 8 years. Count 2, procuring lewd exhibition. Not guilty of the crime of procuring lewd exhibition. Count 3, burglary in the first degree. Defendant is not guilty of the crime of burglary in the first degree, nor lesser included. Count 4, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 5, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 6, defendant is not guilty of the crime of stalking. Count 7, defendant is not guilty of the crime of sexual battery. Count 8, defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 20 years. Count 9, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 10, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 11, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 12, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 13, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 14, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 15, procuring lewd exhibition. Defendant is guilty of the crime of procuring lewd exhibition, and punishment is set at 5 years. Count 16, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 17, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 18, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 19, procuring lewd exhibition. Defendant is not guilty of the crime of procuring lewd exhibition. Count 20, rape in the first degree. Defendant is not guilty of the crime of rape in the first degree. Count 21, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 22, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 23, sexual battery. Defendant is not guilty of the crime of sexual battery. Count 24, forcible oral sodomy. Defendant is not guilty of the crime of forcible oral sodomy. Count 25, rape in the second degree by instrumentation. Defendant is not guilty of the crime of rape in the second degree. Count 26, indecent exposure. Defendant is not guilty of the crime of indecent exposure. Count 27, forcible oral sodomy. Defendant is guilty of the crime of forcible oral sodomy, and punishment is set at 16 years. Count 28, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 29, rape in the first degree. Defendant is guilty of the crime of rape in the first degree, and punishment is set at 30 years. Count 30, sexual battery. Defendant is guilty of the crime of sexual battery, and punishment is set at 8 years. Count 31, rape in the second degree by instrumentation. Defendant is guilty of the crime of rape in the second degree, and punishment is set at 12 years.
You get to see two very different faces of this car thief. On the left, Ryan Stone bragging about his crimes to a female visitor in jail.
And on the right, Stone crying in court as he learned he will spend the rest of his life locked up. It's for a chase and crime spree that went all the way from Longmont to Parker. Today, we learned much more about this dramatic case.
And Denver 7 reporter Mark Stewart joins us now with more on this story. Mark, he didn't seem very remorseful before today.
Indeed, and in fact, you could argue the man behind the wheel here was money hungry. Just released recordings reveal he wanted to profit from all of the clicks of the chase received on our own Denver 7 YouTube channel. A high-speed chase through 5 metro Denver counties. At times, cars were ditched and drivers thrown out the door. At one point, a 4-month-old boy was strapped in a back seat.
Yeah, my lawyer told me I made the news in the UK and Australia.
For the first time since last year's chase, we are seeing a jailhouse conversation. Driver Ryan Stone hoped to profit from his internet fame after the video was posted online.
You get paid by YouTube. So, Channel 7 News, I believe, is going to be the one that gets paid for that. Well, I'm going to contact Channel 7 News.
During his sentencing in court, Stone made an apology, yet wouldn't take responsibility, blaming his escapade on drugs. He asked the judge to give him a break.
I pray you leave me time to start a family of my own with my beautiful wife.
That didn't happen. Stone was sentenced to 160 years in prison.
Those angels up there actually pulled me out of the way.
Trooper Bellum and he almost died. Stone struck him while he was trying to throw out stop sticks.
I proudly wear this badge, and I want to continue to be able to do so, to be able to return to full active duty in the next couple of months.
A crime spree caught from the sky, ending with a career criminal going nowhere but prison.
This guy is a menace, and he is gone from us now, and we are better for it.
The district attorney telling the court Stone's legal troubles date back to 2003 when he was either on bond, probation, or behind bars. I'm Mark Stewart, Denver 7.
We looked into Ryan Stone's claims that Denver 7 made money off the YouTube video. We did not. Our video only has 145,000 views. As with some YouTube videos, if one gets over 1 million views, our parent company probably would have been given $2,000 to $3,000.
This warrant does say that the incident date is May 10, 2014. It reads that the defendant did willfully and unlawfully violate South Carolina Code 16310, murder, when he struck the victim, Odell Fields, one time in the face with a closed fist. The victim fell to the ground and became unresponsive. The victim was airlifted to CMC in Charlotte. where he was placed on life support. The victim remained unresponsive and was pronounced dead at CMC on May 11, 2014. The incident occurred at the Sandbar located at 4124 Selmies Road, which is within the city limits of Rock Hill. So this is what you're charged with. Are you married or single?
Single.
You have anyone that is depending upon you for financial support?
My children. I have 3 children.
Mr. Cobb,
Yes, ma'am.
in reference to this charge of murder, because of the type of sentences this carries, I do not have jurisdiction to set your bond.
I figured that now.
This charge, in terms of a sentence, you would, if you're found guilty or plead guilty, it's possible you're looking at death penalty or life in prison. So, if you have any questions about your rights?
I would just like to stress the family, if possible, if you don't mind. I am extremely sorry for what took place. I was trying to break up a confrontation between him and my cousin, and a punch was thrown. And I was your father. He fell and hit his head. I swear to God, I did not mean this to happen the way it did. I swear to God. I swear to God. I'm so sorry. I promise I am. I mean, I've never in my life been the type of person to do anything like this. I was in the wrong place, wrong time. It was a confrontation and I was trying to defuse the situation. And I'm truly sorry. I really am. I swear to God, I would give my life to have it back. I mean, I'm sorry.
All right, Mr. Cobb, thank you so much. All right, thank you. So I'm going to give you this, also going to give you a check sheet.
Yes.
Ma'am,
Can I just say
you want
something?
to address it to me, then that's you.
I just wanted to know that you pray to God for forgiveness, it'll work out, and I'll keep your kids in my prayers.
I'm sorry. I really am.
Thank you, ma'am.
Time ever, accused cop killer Ashford Thompson breaks down in the courtroom. With tears streaming down his face, he told the judge he's frustrated with the legal process.
I still don't have copies of the things that I've asked for. I don't have a copy of anything. I don't even know what the prosecutor's going to use against me.
Well, probably your statements, Mr. Thompson.
Thompson is accused of shooting to death Twinsburg police officer Josh McTarian in July 2008. Wednesday afternoon, McTarian's widow Holly sat in court as Thompson told a Summit County judge he's having a tough time in jail. He complained that he's not receiving his mail, that he's constantly being harassed.
How can these people just do anything they want? They don't even follow their command the right way. I've been harassed for I don't know how long. I'm trying to hold it in just to get this over with.
Thompson has been through a number of lawyers. His current attorney, Kerry O'Brien, told the judge he's planning on filing an additional 40 motions. The judge agreed to give him 1 more week to prepare. Faced with the death penalty, an exasperated Thompson told the judge he worried about getting a fair trial.
Your Honor, just execute me there because I can't get any kind of justice. I'm tired. I'm at the end of my rope.
Well,
What can I do?
In Summit County, Elisa Amigo, Fox 8 News.